Thank you. Good afternoon, everyone. I'm Marcia Madsen. I'm a partner in Mayor Brown's Washington, D.C. office litigation section and head of the firm's government contracts practice. Joining me today as co-presenters are Lori Lightfoot, Greg Dice, and Howard Waltzman. Lori is a partner in the Chicago office, and she's the co-leader of the firm's commercial litigation practice. She's a former assistant United States attorney in Chicago, and more recently was appointed chair of the Police Accountability Task Force in Chicago. Greg is a partner in the Chicago office and a member of the firm's white-collar defense and compliance practice. He was formerly an AUSA in Chicago, assigned to the public corrections section. Howard Waltzman is a partner in the D.C. office and a member of the firm's government relations practice. Prior to joining Mayor Brown, he spent 13 years on Capitol Hill, including as Chief Telecommunications Counsel at the House Energy and Commerce Committee and General Counsel to former Senator Sam Brownback. Before we begin, I've just got a few housekeeping items. First, as we go along, we hope that you will ask questions by using the Q&A panel on the right side of your screen. We will make every effort to answer questions toward the end of the webinar, and if we're unable to answer your question during the presentation, we will follow up with you once the webinar has ended. Second, regarding CLE credit, we will provide at some point in the presentation a code for you to use. In order to receive the CLE credit, participants must record this code on the virtual sign-in sheet that was emailed to you with the login instructions for today's program. And finally, I have one disclaimer. The views that Lori, Greg, Howard, and I expressed today are our own and should not be attributed to our firm or our clients. So let's get started. Why this webinar? The McDonnell decision has raised a number of questions. We've had a number of questions from clients and others, but questions that have caused businesses to interact with government officials really in any capacity, whether in my case they're government contractors or whether they're companies that interact with the government in a regulated capacity. They've been asking themselves whether their existing compliance programs need to be revised and whether the line between acceptable and unacceptable conduct has changed in any material way. We're going to address these questions from the perspective of criminal prosecutors, government contractors, government watchdogs, and then we're going to roll in considerations involving dealings with campaign finance. We are talking mostly about interaction with federal officials today, but Lori and Greg also have substantial experience with public corruption cases at the state and local level. With that, we're going to go ahead and start with the slide presentation. You can see the overview of the topics on the first slide, and if we can go to the first substantive slide, the overview of the federal bribery-related statutes. I'm going to turn that over to Lori.
Hi, good afternoon, everyone. This is Lori Lightfoot. We thought it would be helpful to kind of set the context for this discussion from a criminal perspective by reacquainting you all with some of the specific federal bribery-related statutes. The first, of course, is 18 U.S.C. Section 201, the Federal Official Bribery Gratuity Act. In this particular statute, the focus is on offering something of value to influence an official act of a public official, and that act could be either to commit some official act or to avoid committing some kind of official act. Section 666, the federal program bribery, that effectively is involved with misusing and misappropriation or embezzlement of federal program dollars by essentially anyone who is receiving or has the ability to influence the flow of those federal program dollars. Of course, Section 1346, the honest services fraud, is a scheme or artifice to defraud, to deprive another of the intangible right of honest services, and we'll talk a little bit about how that particular statute evolved. And then also Section 1951, the Hobbs Act, extortion. For those of you who follow the Sheldon Silver case out of the Southern District of New York. That was one of the counts in the indictment against Silver. And it's robbery, extortion, threat to physical violence, or taking these kinds of actions under the quote-unquote color of official right, which is what was the issue in the Silver case. The definition of interstate commerce, of course, is very broad, and the property issue can either be tangible or intangible, such as information that is shared, and that was one of the issues in the Silver case, which we'll talk about later. Next slide.
Lori, before you go to it's Marcia, before you go to the next slide, I just wanted to make a comment about 201, something that we probably focused on a little more from the government contract perspective, but 201A1 actually also applies to private individuals who act on behalf of the United States. And so given the outsourcing of a lot of federal functions, this definition actually could create liability not only for contractors, but for private sector people who may individually act as an advisor or an expert for a government agency. And I just wanted to note that in passing, because most people don't think if they're acting in their private, if they're a private person, that if they're employed by the government as or not employed, but functioning as an advisor, that they might have liability, but the statute applies to them too.
Okay.
Sorry, go ahead.
I just want to talk briefly about the landscape pre-1987 with respect to honest services fraud. Honest services was a concept that was introduced into the criminal statutes back around the time just post-Civil War as a result of some fraud that was going on in government contracting. It was essentially a sleepy little provision that wasn't really utilized by federal prosecutors much prior to 1987. In 1987, there was a case that the Supreme Court took up, McNally versus the United States, and this actually involved an insurance kickback scheme from Kentucky that involved both governmental actors and non-governmental actors. Two of the defendants in that case challenged their convictions and argued, in effect, that the honest services conviction, which was brought under the mail fraud statute, couldn't stand because they owed no fiduciary duty to the public. The convictions were ultimately reversed by the Supreme Court that argued that in a decision was dissent, that the mail fraud scope was really limited to the protection of property rights, and that if the Congress wanted to expand the contours of the mail fraud statute, that it should do so with specific legislation. And in fact, that's exactly what happened approximately a year after the Supreme Court's ruling and McNally. The Congress passed 18 U.S.C. 1346 and specifically defined the honest services provision. One of the other, of course, notable cases in the evolution of the honest services statute is the Skilling case. This was Jeffrey Skilling, the head of Enron, was convicted for a range of different fraudulent acts and self-dealing. That conviction, in part, was overturned regarding the honest services provision. And there, the issue was the application of honest services in the context of what the court described as a self-dealing action that really just involved Skilling's betrayal of his fiduciary duties related to Enron itself, and not specifically involving any particular government actors. As many of you may recall, when the Skilling decision came down, there was a significant amount of commentary as to whether or not the honest service provision had any viability in the wake of the Supreme Court's decision in Skilling. I think many of us believe that those concerns were overstated, but obviously that now leads us to the McDonnell case, where the Supreme Court has opined again about what the parameters and scope of the honest services statute can be in the context of actual official acts on the part of a government official. And I'm now going to turn it over to my colleague, Greg Dice, who's going to get into the weeds a little bit about what the McDonnell case involves. Greg?
Thanks, Lori. So the McDonnell case, Lori talked about in her first slide the various federal bribery-related statutes that are out there. And the ones at issue in McDonnell are first, honest services fraud, which Lori was just discussing, and then also Hobbs Act extortion, which also incorporates an official act requirement. And the question before the court was, what are the contours, what are the scope of official acts that fall within these statutes targeted at official bribery? Just to take a step back and set the table in terms of the facts, many of you are familiar with the facts, but McDonnell involved an individual, Johnny Williams, who is the CEO of a company, Star Scientific, and he had developed a nutritional supplement, Antablock, and he was seeking FDA approval for that supplement as an anti-inflammatory drug. In order to achieve that, he needed to have independent research on the health benefits of Antablock, and in order to accomplish that, he wanted Virginia universities to conduct such independent research pursuant to state grants. And therein, that was the background, the context in which he began to have interactions and dealings with Governor McDonnell and Governor McDonnell's wife. In terms of the benefits that flowed to Mr. McDonnell, Governor McDonnell and his family, that wasn't really an issue in the case. There were loans, there was a Rolex, wedding gifts, trips, use of a Ferrari, etc. As Chief Justice Roberts noted in his opinion, tawdry tales of all sorts of things. And so that part of the quid side of the quid pro quo that is required for official bribery was not really at issue in McDonnell. What was at issue is the quo side, the official action side. And the official acts that were alleged by the government are what are set forth on this slide. And you can see them: arranging meetings, hosting and attending events, contacting other government officials, allowing Williams to extend invites to gubernatorial events, and then recommending that other government officials meet with Williams and colleagues to discuss Antablock. And so all of these things really fall outside the scope of what we would say clearly falls on the side of official action, and are more in the gray area, even before McDonnell, the Supreme Court's decision in McDonnell. And one of the arguments that was made by the government, DOJ and McDonnell, was focusing on these acts that more broadly, all of this related to, these were official acts because it related to Virginia economic development, really something very broad and very amorphous, and that clearly troubled the court. Next slide. So what the Supreme Court did in McDonnell was to very much focus the attention on how do we define official acts. And in defining official acts under Section 201, the court first noted that the government has to identify a particular question, matter, cause, suit, proceeding, or controversy that may at that time be pending or may be brought before the public official. And that language, question, matter, cause, suit, proceeding, or controversy, that comes straight from the statute. And the second thing that the court held was that the government must prove that the public official made a decision or took action on that question, matter, cause, suit, proceeding, or controversy. So again, very much laser guiding the focus on what is the question or matter or any of the other things that is at issue, and that with respect to the government official took action or made a decision on. Next slide. And so the court framed the two issues as follows: whether arranging a meeting, contacting another official, or hosting an event without anything more, whether that alone can be a question, matter, cause, suit, proceeding, or controversy. And then the second issue, as the court framed it, was if not, in other words, if the mere act of setting up a meeting, contacting an official, hosting an event can't constitute an official action, whether arranging a meeting or taking some of those other actions akin to arranging a meeting can be a decision or action, again, language straight from the statute, on a question, matter, cause, suit, proceeding, or controversy. With respect, you can go to the next slide. With respect to the first issue, Marcia, do you want to address the Supreme Court's holding on issue number 1?
Sure. Howard can jump in if he wants to. The court held that a typical meeting, telephone call, or event arranged by a public official without more does not qualify as a question, matter, cause, suit, proceeding, or controversy. So what would qualify? Factors noted by the court in its opinion are very much associated with the formal, and I would highlight that word, exercise of governmental power, such as the lawsuit, a hearing, or an administrative determination. And for the folks who work in my space, that could be basically anything to do with award or administration of your contract. But formal exercise, focused, concrete, and circumscribed, for example, the kind of thing that can be put on an agenda, tracked for progress, and then checked off as complete. And third, something within the specific duties of an official position, focusing on the function conferred by the authority of his office. So those were the court's touch points. Howard?
And so with respect to Congress, I mean, obviously the court's language on, Marcia's sort of first point isn't necessarily directly relevant in terms of talking about a lawsuit, hearing, and type of hearing the court was probably talking about, or administrative determination. But these last 2 points are really important, because when you're talking about legislation and, any kind of act tied to legislation, whether that's voting for legislation, potentially even co-sponsoring legislation, willingness to move legislation, that's really, in my mind, what comes in this second bullet. And then, certainly, again, with members of Congress, I mean, something within the specific duties of that official's position. But for members of Congress, it's going to be much broader scope than, sort of executive branch agency officials. And so that's something that, notwithstanding the sort of limiting nature of a lot of aspects of this decision, that is indicative of the fact that, for members of Congress, there's still a wide swath of activity that comes within this law.
Yeah, I was just going to make a comment, the notion that there's a typical meeting, telephone call or event. I mean, it'd be hard to categorize them. I was thinking in my own mind, how would you categorize them? There's so many potential flavors of them. Next slide.
So as Marcia and Howard just explained on that first issue, whether arranging a meeting or hosting an event, contacting an official, whether that standing alone can be a question, matter, cause, suit, proceeding, or controversy, the Supreme Court clearly held no. So then the court moved on to the second issue, which was if that arranging a meeting standing alone cannot be official action, can it be a decision or action on some other question, matter, cause, suit, or proceeding? And on that question, the first step that the court took was to identify, okay, well, what are the acceptable, were there acceptable questions or matters at issue that had been argued and proven in the, by the government in the McDonnell case. And the Fourth Circuit had identified 3, which the Supreme Court approved of. And again, I think this falls within the contours that you just heard Marcia and Howard describe. Number 1, the initiation of university research. So actually, if one of the universities was to make that decision to proceed with a study. Number 2, a financial grant from a state agency for the study of anatobine. There was a state agency, the Virginia Tobacco Commission, and Williams was seeking a state grant to fund the research from them, and the court held that that was sufficient question or matter that could support official action. And then the third one identified by the Fourth Circuit and approved by the Supreme Court was a decision for state employee health insurance plans to cover Anatoblock. So what the court held was any one of those 3 things could be official action, and then the question became whether McDonnell's conduct, which again was limited to setting up meetings and things of that nature, could, in connection with those questions or matters, fall within the definition of official action. And what the Supreme Court held was that those things, you can see there the rationale of the test, was those three things were sufficient because they were focused and concrete, they involved a formal exercise of government power, and they were similar in nature to the more specific terms used in 201, a lawsuit, administrative determination, or hearing. So then next slide, please. So then they turn to the question of what constitutes decision or action, and tried to identify a test. And it's a little difficult to glean what the test might be. Subsequent cases will flesh that out. But aside from things that would clearly be official action, initiating the study, the financial grant itself, the court noted that two categories of conduct might cross the line. And one would be an official, public official's use of position to exert pressure on another official to perform an official act. And then second, using one's official position to provide advice to another official, knowing or intending that such advice will form the basis for an official act by another official. So, in other words, again, setting up a meeting, hosting an event, contacting an individual, that standing alone isn't enough to fall within the definition of official action. But if you do take those steps with a view towards exerting pressure or providing advice on some other question or matter, that, under the court's holding, could fall within the definition of official action. And where that line is drawn, that'll have to be fleshed out by subsequent cases. Next slide, please. It's important to note, and sometimes when you read the press reports, it's perhaps a little difficult, or it would be easy enough to be confused as to what exactly the Supreme Court held in McDonnell. The Supreme Court did not hold that McDonnell's conduct, Governor McDonnell's conduct, could not violate the statute, Hobbs Act extortion, or honest services fraud. They left that question for the Fourth Circuit on remand. Instead, what the Supreme Court's decision was very much anchored in was the fact that the jury instructions were too loose, did not sufficiently circumscribe the discretion of the jury to find official action. And in reaching that conclusion, the Supreme Court focused on three things, and they're laid out here in the slide. First, the Supreme Court held that the district court's instructions didn't adequately explain to the jury how to identify question, matter, cause, suit, proceeding, or controversy. In other words, those tests, those factors that Marcia and Howard were talking about, the formality of it, is it sufficiently circumscribed and defined, and is it part of an official's duties? The jury didn't have that background, and therefore they could have found official action based on simply setting up a meeting, and the Supreme Court held that would not be sufficient. The second point that the Supreme Court made was that the jury instructions failed to inform the jury, again, that question, matter, suit, proceeding must be specific and focused and something other than a broad policy objective. Again, as I mentioned, one of the things that the DOJ was arguing in McDonnell was that Virginia economic development enough, and the governor's interest in that, that was sufficient to support official action. The Supreme Court clearly rejected the notion that something so amorphous, something so broad could support a finding of official action. And then the third point that the Supreme Court noted was that the instructions failed to instruct that the decision or action that the governor took or agreed to take had to be associated with that particular question, matter, cause, suit, proceeding, or controversy. So again, very much focused on the jury has to understand that there are limits on official action, and those instructions have to guide them in reaching that conclusion, as opposed to the instructions in McDonnell, which would have permitted them to find official action based on simply setting up a meeting, inviting people to gubernatorial events, which the Supreme Court clearly held was not sufficient. Next slide.
So at this point, the case is in the Fourth Circuit, and the court has to convince itself that there's sufficient evidence that McDonnell committed an official act as that has been defined now by the Supreme Court. And obviously, if the court determines that there is sufficient evidence of official act, the Department of Justice is going to have to make a decision as to whether or not it's going to go forward in a further prosecution of McDonnell. And of course, there's the case of his wife that's also lingering out there. So I think their calculus will have to also take into consideration the evidence against Mrs. McDonnell in light of the Supreme Court's decision. And we'll talk about this a little bit more, but one other point that I want to make before we move to the next topic for discussion. It felt like the Supreme Court believed that no matter how odious Governor McDonnell's conduct had been and how much he was compromised himself, that there wasn't enough there to link up the gifts and benefits that he and his wife received with the actual actions that he took or intended to take. Now, we're going to talk about other cases that are on very different points on the spectrum, but I think the takeaway, if you're a prosecutor, and perhaps the takeaway if you're somebody who's interacting with the government, is that there's got to be a lot more. The court obviously is going to be comfortable if there's actual money that is exchanged in contemporaneous connection with some kind of action, or if there's evidence that there is a deal and an agreement that's been struck, that is going to be the quid pro quo. But they were uncomfortable with the tenuous nature of those connections in the McDonnell case. Go ahead.
Oh, no. The other point I would make along the lines of what Lori's making, and it remains to be seen whether the Justice Department is going to push in McDonnell. I mean, they could simply walk away and not have the Fourth Circuit reach a conclusion on the question of whether there was sufficient evidence that Governor McDonnell engaged in official action as defined and circumscribed by the Supreme Court's decision. And so the Fourth Circuit is really going to be the first court to have to wrestle with what is going to be, I think, a difficult line-drawing problem for courts, and therefore for those people who are trying to anticipate where the line is. And that line really focuses on this idea of when is a government official exerting pressure? When is a government official providing advice? And sometimes that's going to be clear, but in other instances it's going to be difficult. And that's where the action is going to be if the DOJ decides to push and the Fourth Circuit has to make that decision. It's going to be very much focused on trying to figure out where that line's going to be, and that'll be the first in a number of lines of decisions in the coming years that are hopefully going to provide sufficient guidance, because right now there's a little bit of gray.
And just one last point on that. It's hard to see DOJ walking away from this prosecution, even in light of the Supreme Court's ruling, although the government never likes to lose, and particularly lose in a high-profile case such as this. It could also be that Second Circuit is looking at the cases of Dean Skelos and former Speaker in New York of Selden Silver will also wrestle with these similar issues, and we'll talk about those cases in a moment. But I'm not going to turn it back over to Marcia. Let me go to the next slide. To ask the question of whether or not the McDonnell case really moved the line on what is official acts in the context of the honest services case. Marcia?
Thanks, Lori. So looking at the next slide, I mean, this is the question people are asking, right? Does the line of acceptable conduct move? And the Supreme Court was very clear that it was rejecting DOJ's view, and this is a quote, that nearly anything a public official accepts from a campaign contribution to lunch counts as a quid, and nearly anything a public official does, from arranging a meeting to inviting a guest to an event, counts as a quo. So they rejected that very broad position that the government was taking in that case. If you haven't had a chance to study the opinion, at least this is my view, but the court appears to have been influenced substantially, I think, by the fact that there were a number of amicus briefs filed by former federal officials. I think there were 6 former attorneys general from Virginia, as well as 77 other former attorneys general who filed amicus briefs and commented on the breadth of the DOJ position and what its impact would be. And you see the court responding to that. They cite the Sun Diamond case and the Stevens case. This is not Senator Stevens' case. It's a Pennsylvania case about animal cruelty. But for the point that you can't basically construe a criminal statute broadly on the assumption that the government will use it responsibly. So the court was very focused on constraining the definition of the terms that we've been discussing. Howard, did you want to jump in?
Well, just that, I mean, as we'll get to later, I mean, you know, campaign contributions and things like meals, et cetera, do come into play when you're interacting with both members of Congress, their staffs, as well as other federal agencies that are non-contractors. But it is important to note that it's not, I mean, as Marcia says in the slide, I mean, that not everything that you do is a quid, and not everything that a member of Congress or an agency official does is a quo. But that said, as we'll get into later, there are still some cautions that we are going to recommend in terms of how you deal with that interaction.
If you go to the next slide, the top line here, where the Supreme Court noted constitutional concerns, very much follows on what Howard just said, because one of the things that the court was looking at is, and we've all heard about this in the news recently, right, that the Virginia statute itself was pretty lenient, pretty permissive. And the court said, look, it's basically up to the voters in that federalism issue. It's up to the voters in that state to decide, you know, what the ethics standard it expects of its public officials are. And at least at the time, the Virginia statute was quite liberal. So there were these constitutional concerns as well. But, and Howard, you probably want to comment on this too, but, you know, at the bottom line, what the opinion does is clarifies that things that public officials routinely do to assist constituents in dealing with government bureaucracies should not be construed as an official act. And there's some examples here on the slide. And a lot of us who practice law in Washington do a lot of this ourselves, right? Find the right agency, find the right bureau, the right office, or arrange a meeting so that a constituent can present their concerns and get a fair hearing. Some of this is just penetrating the bureaucracy and getting a chance for somebody to talk and present their position. But it's worth being mindful of the warning in the case that a public official's efforts could cross the line if they're designed to exert pressure or provide advice, and obviously, as we just said, that's going to be determined later. Do you want to add anything?
Yeah, I mean, the thing that Marcia just talked about, these are absolutely what, I mean, you know, why members of Congress are there, why their staffs are there to help, you know, deal with agencies, you know, get through the bureaucracy. I mean, when I was a congressional staffer, there were many times where, you know, both just individual constituents as well as companies that were having very difficult times just even getting answers out of whether it's the Social Security Administration, the Veterans Administration, procurement office within DOD. I mean, there were a ton of examples, but, you know, as the Supreme Court said, those don't constitute an official act, but those are absolutely what, you know, I mean, the oversight function of the legislative branch, the oversight over the executive branch is a core responsibility, and it's done every day.
Next slide.
So go ahead.
Yeah, Lori, go ahead.
I've given you the teaser a couple different times, and now let me talk a little bit about some current cases that have been in the news that you may have been following, and what the potential implications are of the McDonnell decision on those cases. The case involving Senator Bob Menendez from New Jersey is still at the early stages. There's been, Menendez and his lawyers have taken several whacks at trying to dismiss the indictment in that case for a variety of grounds, and I believe it's now up in the Fourth Circuit on appeal. But Menendez, I think, raises the same issue that Howard was just referencing, and certainly he's argued this, is he essentially says, hey, I was just doing my job. Yes, I made calls. Yes, I tried to cut through the bureaucracy on behalf of someone who was in need, but that's what I am supposed to do as an elected official. So his case is a little more like McDonnell, although I think the government would argue that Menendez was much more heavy-handed, and he himself got specific gifts in return for the actions that he was taking on behalf of his co-defendant in that case. Skelos and Silver, while in Skelos there may be a jury instruction issue that might give him a little bit of hope, and obviously both sets of lawyers in those two different cases have made public statements that they're salivating over the Supreme Court's decision in the McDonnell case. I'm not so sure that at the end of the day they're going to be benefited from the court's decision in McDonnell, in part because they are on different points of the spectrum from McDonnell. Here, there was, in both of those cases, there was substantial evidence of a quid pro quo that Skelos and Silver were using their respective positions as high-ranking and powerful officials in New York State government to benefit themselves, in the case of Skelos, benefit his son, and that they, in fact, received money and other benefits as a result of that pressure and influence that they brought to bear by exerting themselves as public officials. It's a much more kind of straightforward extortion, bribery case than I think the McDonnell case is, and I think that will be a challenge for them to take advantage of McDonnell. As we are sitting here today, former Governor of Illinois, Rod Blagojevich, is back in front of the trial judge going to make similar arguments that the acts that he took in his case that netted him a 14-year prison sentence, not unlike the McDonnell case, were not really official acts, weren't consummated, and certainly don't warrant a 14-year prison sentence. We'll find out, hopefully later today, whether or not those arguments are actually going to bear fruit for him and be beneficial. I think there's a lot of skepticism that they will, but that's another case that the McDonnell case, I think, has a potential to influence. As far as going forward, I think the government will be much more cautious about bringing charges in cases where there are clear-cut agreements, clear-cut quid pro quo against government officials, because they've now twice been, if you count Skilling, carved back, and their ability to stretch the honest services and other bribery statutes to cover conduct that, again, while may be offensive, may violate ethics rules, might not actually be criminal.
Yeah, and I think to echo Lori's point, I think you can view corruption prosecutions like these as falling into two buckets, and I think in many respects McDonnell was trying to highlight those and note those. On the one hand, you have those cases where the official on trial is actually the one who was going to take the official action. It was something directly within the purview of their scope of responsibilities. Those types of cases aren't going to be as impacted by McDonnell, and I think that's when Lori was talking about Skelos and Silver. In those cases, although there were some allegations and some proof along the lines of one step removed, in other words, influencing the official action of others, you had evidence and proof of something clearly within the scope of their official responsibilities. Menendez, time will tell, and again, that case is yet to go to trial, and we'll have to see what the government's evidence looks like. But at least based on the briefing and the indictment, it appears that that case could fall closer to the McDonnell line, where Menendez is advocating and trying to potentially influence the official action of others. And so that falls into that second bucket. And I think that's going to be the bucket where you're going to see the government potentially think long and hard about, do we have sufficient evidence to meet what is a little bit of a blurry line set forth in McDonnell, this idea of exerting pressure, giving advice to influence, to try and impact the official action of some other public official. That second bucket, I think, is where McDonnell is going to have a much greater impact.
And, you know, we've obviously been talking about these prosecutions at a kind of high state level. Obviously, they will impact what happens, and federally, it will happen, impact other federal public corruption cases, but also at the state and local level. And we'll talk about those a little bit more towards the end of our program. But at this point, I want to turn it back over to Marcia to talk about how these issues play out in the context of government-contractor relations, where you're frequently interfacing with government officials as a matter of course within the scope of your contract. Marcia?
Thanks, Lori. So I'm going to preface these comments by saying a lot of what I'm going to talk about relates to people who have business relationships with the government as government contractors, but it is much broader than that as well, because a lot of these laws also impact anyone who has a business relationship with the government, whether it's a contractor or someone who's with a regulated industry who's appearing regularly in front of government personnel. Government contracts gets a lot of attention, as you can see on this slide, because the size of the spend is so high. When you look at the size of the spend, you know, last year, $430.5 billion, and the amount of government interaction that takes place for companies or individuals that are regularly have a business relationship with the government, that's why the rules here are stricter. Some of them are unusual, but it's also why some of the rules that apply to everyone have special application in this space. Every year, millions, literally, of government contract source selection decisions are made by people in the executive branch. And it's because misuse of the office by these people or their influence involves taxpayer money, and it so visibly compromises the public trust. Procurement officials in the government at all levels, whether they're programmatic or people who actually, you know, with warrants who sign contracts, if you interact with private sector people, they're subject to some special rules and special scrutiny under rules that apply to everyone. So there's criminal, civil, and administrative restrictions that apply uniquely and with special force to government contractors, but there are also restrictions that apply to everyone and are just applied strongly to government contractors. Next slide. I just put up here, we're not going to belabor this, the basic standard of conduct that's in the federal acquisition regulation, which sets an extremely high standard for people involved with government business. So conducted in a manner above reproach, complete impartiality, preferential treatment for none, and that transactions involving public funds require an impeccable standard of conduct and strictly avoid any conflict of interest or even the appearance of a conflict of interest. That's what the taxpayers expect. A special concern that applies to government contractors but actually applies to anyone involved with government business is another provision of 18 U.S.C. 201. It's 201C, which is the gratuities provision, although it doesn't actually use the word gratuity.
Pardon me, this is the conference operator. Is there anyone on the line? If your phone is on mute, please unmute it. Once again, this is the conference operator. Is there anyone on the line?
Official would be subject to this statute, not just government contractors. A gratuity, unlike the bribery piece of the statute that we've been talking about so far this morning, a gratuity does not require a quid pro quo, does not. With respect to government contracts, government employees involved with public contracts expressly are prohibited from seeking gratuities under this FAR provision that we've cited here. And government contractors are also subject to special administrative sanctions if, after given a chance for a hearing, the government determines that they offered a gratuity. So next slide. So if you're a government contractor and there's a determination that there was a gratuity offered or given in violation of the criminal statute, in addition to criminal prosecution, the agency has administrative remedies. So they can terminate your valuable contract. They have the normal kinds of breach remedies. And then there's a special statutory provision for DOJ contracts in 10 U.S.C. 2207 that also provides for exemplary damages. These are civil damages. And then, of course, you could be suspended or debarred from any dealings with the government. So there's a very serious focus for government contractors on gratuities, and we're going to talk about the gift rules a little more in a minute. As we note on this slide, the Office of Government Ethics has adopted regulations that define gifts in 5 CFR. These rules are really detailed and complicated. They cover things such as hospitality, or as well as any item having monetary value, which could include services. We could spend a whole session just talking about these rules, which we obviously don't have time today to do, so we're just going to give a couple of examples. There are exceptions, but they're narrow exceptions. So one of the things we're going to talk about in a minute is sort of best practices for dealing with gifts. Next slide. I'm not going to belabor these, but in addition to the bribery-related criminal statutes, there are multiple other criminal laws that extend beyond gifts and are intended to prohibit federal employees from either misusing their office or their influence, trading favors, or giving or accepting benefits. These statutes, these other provisions of 18 U.S.C. apply to everyone, not just government contractors. They apply to all kinds of transactions with government officials, but they are especially relevant to government contracting just due to the amount of interaction that people involved in this area have. So I'm just going to review these quickly. 18 U.S.C. 208 criminal statute prohibits a federal employee from participating personally and substantially in any particular matter, which is a defined term, in which he or a family member has, or a business associate has a financial interest. So this particular provision is aimed at, if it's not giving something to the federal employee, you may be trying to influence the federal employee by influencing a family member or a business associate. Again, it's trading favors, misuse of the office. 18 U.S.C. 209 prohibits federal employees from receiving compensation from outside sources for government work. So if you're in a regulated industry, you can't hire a government employee to work on the side to help you present your case to the government. Next slide. 18 U.S.C. 203 and 205, again, criminal statutes prohibit federal employees from misusing their office and their influence to participate in claims against the government on behalf of private parties. So government contractors and others frequently have claims involving government action that they want to pursue either in an administrative forum or in a court, and a government employee can't, again, work on the side to take your case and pursue it, for example, in the Court of Federal Claims. They can't enrich themselves by having a private law practice on the side. 18 U.S.C. 207 addresses conflicts of interest by former government employees. This is a conflict of interest statute, but again, what it's really aimed at is preventing people from trading on their government position and their influence. So they cannot, they're barred from accepting private employment. They're not barred, excuse me, from accepting private employment, but their ability to use their relationships that they developed inside the government is what's restricted. So regardless of the former official's rank, a former government employee is barred from representing other persons by communicating with or appearing before government agencies or in court concerning the same particular matter involving specific parties. In the case of my clients, it would be a contract or a grant, but it could be other things that that person was involved with for the government. So they can leave government, they can go to work for a company or a law firm, but they can't reappear in front of their agency and attempt to take advantage of influence that they develop there. Howard, did you have a comment?
Yeah, I mean, you know, there are obviously lots of government employees who have lots of experience that benefits companies, that benefits law firms. So it's not a surprise that they would be, you know, sought to be hired by either type of entity. But there are lots of restrictions on what former government employees can do, and even the process for hiring former government employees. And probably the strongest, most obvious is the so-called Obama pledge for the senior administration officials that are, you know, literally barred from going back in and lobbying the Obama administration. Members of Congress are barred from lobbying their colleagues. Staff, and depending upon whether the staff was in a personal office or committee staff or leadership staff, are barred from lobbying their sort of previous employers for a certain amount of time. Agency officials are barred from participating in certain proceedings in which they were involved during their tenure. But also, again, I mean, even in terms of hiring, I mean, you know, to the extent that you're ever considering hiring someone who's, you know, hiring someone from the government, there are important, you know, sort of criteria to follow. Usually, each individual agency has its own sort of either office of, you know, within the general counsel's office or some sort of ethics officer that can help guide the process for, you know, how you can, you know, to the extent you can recruit a former government official, what you can talk about, at what point the government official has to recuse him or herself from participating in any matters, you know, at the agency. But these are all, you know, very important things to understand that don't take away from the value that government officials or former government officials have when they go into the private sector, but it's very important in terms of understanding, you know, the guidelines that have to be followed before you can hire such a person, and B, what they are or not allowed to participate in once they're in the private sector.
Right, so very good point. And the slides we're looking at affect executive branch employees. So if we're all looking at slide 24, just to give you an example of how the 207 restriction applies, if we have an official who's left government, this is the particular matter restriction, and the particular grant or contract or regulatory matter was under that person's official responsibility as a government employee, that person is barred for 2 years. If he participated personally and substantially, he's barred permanently. So if he's the first or second tier supervisor, he's barred for 2 years. If he participated personally and substantially in that matter, awarded the contract, awarded the grant, for example, and we'll see some examples of this in a minute, then the bar is perm, that he can't touch it. This person can go to work for your company or can go to work for our law firm and talk to me and Howard and Greg and Lori about how to approach this agency, but the person can't approach the agency for him or herself. The second bullet involves former senior level officials. They're subject to a cooling off period for 1 year after leaving government. They just have to stay away from their former agency, and they cannot appear or communicate with their former agency. So again, they can have a job, but they cannot reappear in front of their former agency. And then if they were very senior, you know, deputy secretaries, that kind of thing, they're subject to a similar prohibition, but it's 2 years, and it extends to contacts with specific high-level officials at any department or agency. So they can't trade on their influence. Again, it's influence trading that this provision worries about. And the Obama pledge is actually broader than this. It's not statutory, it's just what people had to sign up to. Next slide. We go to 25, please. Okay. This is just an example. It's a DOD-specific example of a revolving door restriction. And I'm not going to get into a lot of detail about most of these, but it's one of a number of unique provisions that exist with respect to government contractors that is aimed at targeting specific behavior. So we're legislating here, Congress is legislating here, targeting specific behavior that's been a particular issue for the government in the past. So it's an individual effort to deal with a particular individual issue. This is a revolving door restriction, and this one applies to a DOD official who intends to work for a DOD contractor within 2 years after leaving DOD. That person's required to get, as Howard was talking about earlier, a post-employment restriction ethics opinion before they can get paid by a DOD contractor. And on the other side, the DOD contractor cannot pay that person within 2 years after he leaves DOD unless that DOD official has received or requested the ethics opinion. And so the contractor obviously has to check, and then the DOD contractor that fails to comply with this puts the burden on the contractor and is subject to administrative sanctions such as contract cancellation or suspension or debarment. Next slide. 26. Another, and we're not going to get into the weeds here, but another targeted provision that people who work in this area are pretty familiar with is the Procurement Integrity Act, which is something else that was enacted a couple of decades ago now in an effort to target specific conduct by federal officials and contractors that was viewed as corrupting the integrity of the procurement process. And these provisions are intended to basically fill what were gaps in other statutes. So just there's 2 points here. One is that present or former government officials who've acted for or advised the government regarding a federal procurement are prohibited, unless the narrow exception applies, from disclosing contractor bid or proposal information or agency source selection information. So there's an information flow restriction, because the perception was that there was value to this information and information was being traded, so now it's been restricted. The second piece of this is that contractors or prospective contractors are not allowed to obtain such information. So the government person or former government person can't provide it, and if you're a contractor and you get it, you're not allowed to have it. You're not allowed to seek it, and if you have it, you're going to have to find a way to get it back. And I just would also note that release of trade secrets is also a criminal violation under 18 U.S.C. 1905. Going to slide 27, there are additional revolving door restrictions, so I'm not going to go into the details here, but basically they keep agency officials who've been involved in making contracting decisions for contracts of substantial value, $10 million or more, from using the knowledge that they gain working on specific matters and taking that into the private sector. 28 is another specific restriction that can be applied more broadly than you might think. It's the Anti-Kickback Act, and it's really intended to prohibit subcontractors from making payments and contractors from accepting payments with the objective of getting a subcontract. So you can't have a quid pro quo here. You give me a contract and I'll pay you. There are criminal and civil penalties and administrative penalties here. There are a lot of prosecutions under the Anti-Kickback Act. And then if we can go to slide 29, I'm just going to point out that there are many other restrictions. There's too many to enumerate that are aimed at reducing opportunities for corruption. And if anyone's particularly interested in these, we'd be happy to talk about them more specifically. But the overarching point here is for people who have business relationships with the government, you have to be extremely careful, and you have to understand that there are provisions that are targeted at very particular conduct that in the commercial sector would be acceptable behavior. And so if you're going to work in this space, you need to be cognizant that compliance with these provisions is essential to protecting your company and yourself. Next slide.
So next I'm going to, next slide please. Thanks. Next I'm going to talk about campaign finance. The House and Senate rules prohibit the use of official resources for campaign purposes. So what this really means is that when you're on, kind of in government space, whether you're in the Capitol, or you're in the House and Senate office buildings, or you're in, the respective state or district offices for senators and members of Congress, neither, the members and staff shouldn't be doing any campaign work, nor should you be in there conducting sort of campaign business. So, I mean, the most kind of obvious thing is do not walk into a congressional office and hand somebody a campaign check. But, the flip side, I mean, is true. The members and staff shouldn't be using their official phones or email accounts for a campaign activity. There has to be a firewall between the use of sort of congressional facilities versus use of campaign facilities, and it's probably not a coincidence that the National Republican Campaign Committee and the Democrat Congressional Campaign Committee and the same on the Senate side are all in close proximity to the congressional buildings, so that members and their staff can, walk down the block and go conduct campaign activity legally without doing so within the congressional buildings themselves. One thing to keep in mind too is that just because you ask for something doesn't mean it'll happen. So even with the Supreme Court's rejection of the idea that nearly anything a public official accepts can qualify as a quid, strict gift rules still apply, and federal officials must take decisions based on more than contributions. So, I mean, certainly no one should ever expect that a member is going to do something for either a gift or a campaign contribution, and that would, fall afoul of the laws as we talked about. Next slide, please. So, practical considerations. While there is a firewall about conducting campaign activity on congressional property, basically on government property, there's certainly sort of substantive conversations that happen at fundraisers and other events. It's not like that the only thing that's talked about at fundraisers is the campaign itself. That said, we certainly encourage you to be sort of judicious and cautious. If you're able to talk about issues important to your company, important to your employees, but nothing should ever rise to the level of a quid pro quo. Washington is a social town. I mean, there are lots of social activities where you may run into members of Congress, where you may run into staff. The gift rules are important to be mindful of. There are also a lot of not just social but political activities where the gift rules are a little kind of less clear in the context of purely political activities and functions. So, I mean, it's good to be mindful that there are going to be interactions you may have. I mean, Congress is different than the executive branch in terms of the types of communications you have. You don't get into issues of sort of ex parte communications or restricted proceedings when you're talking about Congress. But it's just good to be mindful that handing somebody making a contribution to a campaign does not necessarily mean that the member of Congress has obligated him or herself to vote a particular way.
The next slide, we're going to change the subject a little bit here and talk about best practices. And it's got a government contract flavor, but it's broader than that. For companies that do business with the sovereign United States, there is a mandatory provision today in the regulations requiring a code of ethics and mandatory disclosure, which we're going to talk about. This has been in place since 2009. Contractors have been required to have a written code of business ethics and conduct, employee training, internal controls that are appropriate for the size of the company, what they're doing with the government. And the reason is to, importantly, one of the reasons is to facilitate timely discovery and disclosure of improper conduct. So as a result, companies that have any significant amount of government business, at least today, typically have a very robust ethics and compliance program because they've had to struggle with how to put this together. This clause that goes in everybody's contract that's referenced on the slide, the FAR 52-203-13 clause, contains a very draconian provision known as the mandatory disclosure rule. Next slide. This applies to government contractors. Most of the government agencies haven't gotten around to this, although IGs, Inspectors General, love this clause. Under that mandatory disclosure rule, contractors are required, this is a term of art, to timely disclose to the agency IG and their contracting officer whenever the contractor has credible evidence, a term of art, that it has committed, and this is why we're focusing on this rule right here. They've committed a violation of a federal criminal law involving fraud, conflict of interest, bribery or gratuity violations in Title 18. So it directly relates to the kinds of bribery and gratuity things we've been talking about, or misuse of a federal employee's office. So if they're aware of it, they have to make a mandatory disclosure. The other thing that the rule applies to is a violation of the Civil False Claims Act, and a violation of the FAR provisions that are aimed at protecting the integrity of the procurement process could also be a violation of the Civil False Claims Act. So you've got two areas where if you're a government contractor subject to this rule, you would have to report if you would have to timely report if you had credible evidence of a violation. And the teeth in this provision really come from the government's power to debar contractors. In fact, failure to make a disclosure can by itself be grounds for debarment. Next slide. So we thought it would be helpful to talk to you all a little bit about best practices for dealing with gifts and gratuities, compliance programs, and I know there are folks on the call who have these kinds of compliance programs, and people make sort of different decisions about how to slice and dice this, but these are some of the things that I think we would focus on. And these are federal government related, but I think Lori and Greg may comment in a few minutes also about restrictions at the state and local level. So basically our view, based on substantial practice, is that the compliance program a company has for dealing with gifts and gratuities should be really simple and straightforward. And just in terms of some lessons learned. Compliance programs should probably prohibit gifts to government personnel unless those are in very strict accordance with specific policy or have been expressly approved by the head of compliance for the company or council. In other words, no gift unless you've got a specific policy that everybody can tell what the rule is or you've gotten specific approval. Specific guidance should be provided for acceptable gifts, and no other gifts should be permitted. So what this does is obviate the application of judgment by company personnel. This is a bright line approach to gifts and gratuities. And you can see actually from the McDonnell case why this might be desirable. Next slide. So as I mentioned earlier, the Office of Government Ethics has some detailed rules about gifts. And each company needs to decide, what its level of comfort is with applying these rules and how strict to make prohibitions. So as an example, meals are prohibited. So are soft drinks, coffee, donuts, potato chips permitted at meetings? You can say yes or you can say no, but if you said yes, then you got to be careful to monitor, you know, does that start to look like breakfast or lunch? Secondly, the rules permit small items that have little intrinsic value to be provided to government employees. So small plaques, mugs with your corporate logo, little certificates or trophies. Again, are you going to go for letting people do this or not? But if you're permitting it, there's got to be a responsibility for tracking the amount from the company to a specific official, because government officials can only accept up to a total of $50 per year per donor, and it adds up very quickly. There are specific prohibitions, and there shouldn't be any confusion about them. No meals, no loans, no trips, no Rolexes, no tickets, no cars. So you want to be really clear in your compliance program about those things. Next slide. Your compliance program also needs some probably specific guidance for dealing with family and friends who are government officials. One thing that people trip up on periodically is if you have, let's say you have a company Christmas party. If it's a widely attended function, your spouse, your son, your daughter can attend and partake of the buffet or whatever, but you can't bring somebody to the company Christmas party, even if they're a family member, just because of their government office. We see some of the same issues with people who vacation in luxurious places with their relatively luxurious places with family and friends. You have to be very careful that you're not inviting someone to your beach house just because they work for a particular federal agency. No gifts can be provided from your company, and nothing can be given, as I said, to a person because of their position. So specific guidance in the compliance program is really important. For a lot of companies, there are people who are government-facing, marketing, contracting, program management, regulatory affairs, who are government-facing. These folks should get regular training and clear instruction on the limits of their discretion. And then lastly, any good compliance program has a means for reporting, a hotline for reporting violations to company compliance officials. So we've designed a lot of these programs. We're happy to answer questions, but these are really just basic ground rules. Next slide. Thanks, Lori.
Yeah, so I'm going to just close out the discussion with a high-level overview of kind of touch points and guidelines that you can use in thinking about your compliance program, which I'm sure many of you know. Obviously, the DOJ's Federal Prosecution of Business Organizations and sentencing guidelines provide a lot of detailed information about what the government's expectations are for compliance programs and what they're going to be looking at as to whether or not they charge you for acts or omissions by one of your employees. And similarly, the DOJ and SEC have FCPA resource guides that also provide similar kinds of guidance. But in general, as Marcia has touched upon, you have to think about the tone at the top is obviously critically important. What are the specific policies and procedures? How often do you train on those policies and procedures? Are you doing a periodic audit or risk-based review? What's the oversight of the compliance function, and who owns the compliance function within your organization, and are they of a significantly high position where they can actually influence the culture of the organization and imbue it with a compliance and risk-based culture? And what's your process for internal reporting? And are you following up and investigating any allegations of misconduct on the part of employees? And if that's found, what actions do you take? Next slide. As we've hopefully left you with a clear impression, gifts and hospitality for government officials really do present significant risk at every level of government, from federal down to the municipal level. It's very important that you have a robust compliance program in place. And really, I'd like to tell clients, you have to think about Who is your weakest link? Is it that salesperson that's going out and interfacing with government workers? Do they have an understanding of the restrictions and ethical rules that apply to government actors that they may be calling upon for business? And do you make sure that they understand those limits in their dealings and not think that government actors either will tell them what the limits are or that government actors are like private sector actors where you can wine and dine for the most part without having any worries or concerns. But the best compliance program means nothing if the people who are on a regular basis touching and interacting with government officials really don't get it and aren't trained to make sure that they stay out of stepping on landmines. That's what's, I think, critically important and a takeaway from one of the big takeaways from today's session.
Yeah. Hey, Lori, it's Marcia. I actually had a question for you and Greg because we had talked about this a little bit, which is a lot of the folks, I think, on the call probably do business in multiple jurisdictions, so they may interact with federal officials, state and local officials. And, of course, states, as exemplified by Virginia, have all kinds of different standards. I mean, do you want to comment at all on the sort of the problems dealing with different layers of government and some of the states who may have stricter standards than others?
Yeah, I'll start and then I'll pitch it to Greg. And it's a great question. I think it's incumbent upon the folks who are engaged in that business, if they're moving from jurisdiction to jurisdiction. And for example, if you have a sales force, it's not uncommon that they're going to be dealing with somebody in, say it's the Midwest, they're going to be dealing with somebody in Illinois, in Michigan, in Indiana, and the rules may vary both state to state and frankly jurisdiction to jurisdiction within those states. So it's worth spending the time on the front end to identify the geographic areas in which your folks are going to be involved and making sure that you have a very crystal clear understanding of what your responsibilities are. For example, in the city of Chicago, there are ethical rules that are built in to the contract language and also outside of the contract, economic disclosure and other disclosure information that has to be given. Baked into that are an assumption that you will know the rules of the road, that you understand what the ethical limitations are, and that you're committing to abiding by whatever the applicable ethics standards and state statutes that might apply. So you can't take for granted that what your knowledge is in one area at one level of state government or federal government or municipal government has equal application to another jurisdiction, because that's the exact situation where you're going to get yourself into trouble.
Yeah, and I think the idea that state laws differ is something to keep in mind, and it's also important to keep in mind that a federal case can be made out of the violation of state law pursuant to a favorite tool of corruption prosecutors, the Travel Act. And it wasn't something we mentioned up front, but it's basically if you cross state lines to violate certain state laws, which would include state bribery laws, that can be a federal offense. And so it's not just state ethics rules and those types of things, which can certainly get you into trouble. It can also rise to the level of a federal prosecution. And so understanding those rules, staying very far from the line with your compliance program is crucial. The other thing to think about, it's not just going down to the state level. You've also got, many of the listeners here have international operations, and you have the FCPA. And your compliance programs aren't just focused on your domestic activities, they're also focused on your international activities. And the FCPA doesn't have the official act requirement, so to speak. In other words, it's broader. And so whatever happened in McDonnell, that really doesn't impact what you see in the FCPA. And again, your compliance program is going to be applied globally. And so really I think the takeaway from McDonnell is important. It certainly cabined and limited the types of activities a public official can engage in that would fall within the definition of official acts. And so yes, it did scale back, but to me, to the compliance function within the company, the safe bet is to focus on the quid, and then you don't have to worry about the quo. In other words, you know, any sort of gifts and hospitality to government officials the safest bet? Don't do it. But if you are going to do it, it has to be very, very, very circumscribed and subject to very, very tight controls because it's tricky business. And so, McDonnell talks about the quo, that scope of activity, but really from a compliance perspective, focus on the quid and anything that could be construed as a benefit to a government official.
All right. Any other comments that you, Marcia, you or Howard want to add?
Well, we have a question pending from one of the participants that I think we should address. I think there's only one here, but the question is, how does what we've been talking about today apply where the government may be using a contracted agent, like an insurance broker, to acquire services such as insurance coverage? And, would something considered a gratuity provided to an employee of that broker be caught? It's an interesting question. I think if you remember at the very beginning when I was talking about the bribery statute, I said there's a provision that is used that applies to anyone that is working for the government or representing the government or doing the government's business. So certainly with respect to the bribery statute, and the gratuity statute applies to both the giver and the receiver. So I think the point here is, what's the intent of the gift, if there's one made to someone who's acquiring something on behalf of a government agency, and if the intent is to influence that person's actions, then that probably is a violation. And the question about being caught may be a different question, but the kinds of compliance programs we're talking about most companies have in place today are such that if that becomes known, it's probably going to be the subject of a disclosure or a hotline report. I don't know, Lori, Greg, you want to comment?
No, I think that's exactly right.
So before we wrap up here, do any of you folks in Chicago have any additional comments? I've got one, but I will defer to you for the moment.
No, I think we've covered everything and addressed all the issues or questions that we wanted to cover. Okay.
So just to wrap this up, as Greg said, we think, at least I think, McDonnell moved the line in the sense of giving pretty clear guidance that routine things that government officials do are not going to be subject to the bribery statute. But the unanswered question here is the exert pressure or exert influence part, and what the evidence there would look like, and we don't know the answer to that yet. So it helps, it adds clarity, but it doesn't resolve all of the issues that are out there. And I think with that, we'd like to thank everyone for participating, and if you have questions, I think any of us would be happy to answer them. Thank you.